All right. Well, good evening, everyone, and welcome. My name's Emily Voss, and I am the Senior Manager of National Programs and Professional Learning at the Center for Civic Education. I'll be moderating our conversation this evening. On behalf of the Center for Civic Ed, I am really delighted to welcome you to tonight's session in our 60-minute Civics series. And tonight's subject is the Constitution as living document, progress or departure. And our 60-minute civics programs are designed to bring teachers, scholars, and civic educators together to explore big questions in government and history with a focus on how they connect to the classroom. And we're really happy you're with us. We're excited by the very strong interest in tonight's topic and looking forward to a lot of great questions from you. So about tonight, our roadmap for the evening is that we're going to start with a kind of single framing idea that will guide our conversation. And this idea is the Constitution doesn't interpret itself. And so, we all understand that the Constitution still matters very much. Most people do agree that it does. And the debate is how we decide what it means today and who gets to decide. So that question shows up in courtrooms, in classrooms, in Congress, and in everyday civic life. And that's what we'll be unpacking together this evening. So here's how tonight will flow. We'll spend some time with our guest scholars laying out broader ways that people think about constitutional meaning. And then we will talk about who actually interprets the Constitution in practice and look at a couple of concrete examples to make this less abstract. And after that, we'll hear from one of our amazing mentor educators who will show us what this kind of constitutional thinking looks like with real students. So, and we'll make sure to leave question time for you as well. So please feel free to drop questions into the chat as they may occur to you. So if you are brand new to our series, welcome. The Center for Civic Ed is a nonpartisan, nonprofit organization dedicated to promoting an informed and engaged citizenry through high-quality civic education. And many of you know the center through programs like We the People and Project Citizen. And our goal with sessions like this is to support teachers with content, tools, and language that can help strengthen civic learning. And tonight, I'm really pleased to be joined by two amazing scholars who bring incredibly deep expertise and, just as importantly, a shared commitment to civic education and to civic educators. First, we have Dr. Henry L. Chambers, who goes by Hank. Hank is a professor of law whose work focuses on constitutional law and related areas. And he spent many years thinking about how constitutional ideas are taught and understood beyond law school. In addition to his academic work, Hank has been very involved in civic education, including frequent work with We the People, and he lectures sometimes at James Madison's Montpelier and for programs for educators and public servants. He also served as a Special Assistant Attorney General for redistricting in Virginia. Hank brings a very strong grounding in constitutional structure and history, along with real appreciation for how these ideas show up in the classroom. We're also joined by Matthew Brogdon. Matthew is the Senior Director of the Center for Constitutional Studies at Utah Valley University and has taught American politics, constitutionalism, and political philosophy at the university level. His scholarship focuses on American constitutionalism and the federal judiciary, including how constitutional ideas were debated and shaped in the early years of the Republic. His work on the First Congress and the federal courts has been nationally recognized, and he's currently completing a book on the constitutional foundations of the modern judiciary. Matthew brings a perspective that bridges the constitutional theory, historical development, and contemporary debates about how the Constitution works today. And I am grateful to both of them for being part of today's conversation. And, not just to explore these ideas, but also to support teachers and students in making sense of all of them. And later in the session, we'll be joined by Erica Pagotto, whose perspective will help ground tonight's discussion in real classroom practice. Erica teaches 8th grade American history at Lehighton Area Middle School in Pennsylvania, and she works closely with We the People as a mentor teacher, as well as with Project Community. In addition to her teaching, Erica serves as her school's social studies department chair and is deeply involved in her school community in a variety of roles. And Erica will share how her students grapple with constitutional questions by engaging in exactly the kind of reasoning we'll be talking about tonight. So her perspective will help show what constitutional interpretation looks like when it's developmentally appropriate, inquiry-based, and genuinely student-centered. So looking forward to this conversation with all three of you. And before we get started with our conversation, I do want to flag a quick resource that may be helpful as we go. If at any point you would like to reference the full text of the Constitution, a clear and reliable version is available through the National Constitution Center. I'm sure many of you are already familiar with this. Maybe you have it bookmarked on your desktop browser, but it might be useful for you tonight. We will be sharing some slides. You don't need to pull it up right now, but just wanted to make you aware that that is available if you choose to use it. All right, so with that, I'm going to highlight our scholars here, and I am going to kick us off. So, when people argue about the Constitution being living or not, what are they really disagreeing about? Matthew, will you please take it away first?
Oh, thank you very much, Emily. I'll just say to start with, I am delighted to have this opportunity to chat with you all. Um, I know all of us in the educational sphere who are engaged in trying to acquaint the rising generation with our constitutional inheritance are especially excited about the fact that it is January 2026, the 250th anniversary of American independence has arrived, is arriving. And That's an auspicious year for us all because this is a chance for us to highlight the important events that mark the creation of our political order. And that, of course, brings us to the issue we're all talking about. We have a constitution that is originally written uh, not 250, but about 240 years ago. Um, and that text is still with us as amended. So we have a constitution that's been amended over time through a formal process laid out in Article 5 of the Constitution. And I actually want to start this discussion of whether the Constitution is a living document. We usually talk about living constitutionalism versus originalism, some notion that the Constitution is evolving, which there's no doubt of that. The Constitution we have is not the same one we had in 1788 when it was first ratified. But there's a real dispute about whether the Constitution is fixed in some way that binds certain actors, especially the people who interpret and enforce it, are judges, presidents, states, the legislature, all of these folks. And I want to start with a quote. I actually stuck it in the chat. I don't have much of a presentation for you, but this quote from George Washington's farewell address, which I think is a really forthright statement in a way of the originalist idea about how the Constitution binds us. So here's the quote: "The basis of our political system is the right of the people to make and to alter their constitutions of government." I do think it's important that's plural, constitutions, because states all have constitutions too. "But the Constitution which at any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. The very idea of the power and the right of the people to establish government," so our right to establish a constitution in the first place, this idea of popular sovereignty, "presupposes the duty of every individual to obey the established government." So if we say we the people can make a constitution which functions as a law for government, that is another way to talk about we the people in that constitutional sense is as a constitutional majority. We think about popular sovereignty, but we talk about it in all sorts of settings. We think, the majority elects the next president, usually. The majority in any given congressional district is going to pick their next member of Congress or their next member of their state legislature and so forth. And maybe we should say a majority of the voting public that shows up to vote. They're going to choose that person. So we could talk about that as popular sovereignty, but the Constitution presupposes a different kind of majority, a constitutional majority, some embodiment of we the people that speaks in a way that we don't speak in a normal election. When we show up at the polls and we pick a president or we pick a state legislature, we're not acting as we the people in quite the same sovereign capacity as when we make a constitution. Because when we make that constitution, we're assuming we're making a law. We're not just choosing people for it to occupy offices in the government, make laws on our behalf. We ourselves are making a law that will bind our government. That is, that will bind even the people we ourselves choose in the future under that Constitution. So Washington is getting around to this. And if you wanted like just a succinct term to describe this, Washington's talking about the idea of constitutional fidelity. The people who administer the Constitution, the people who live under it, have a responsibility, if they believe the people are self-governing and the people are sovereign, to obey the Constitution that the people have in fact made until we change that Constitution by some authentic and official act of amendment. Now, we could do something else. There's another option, and even Washington would recognize this. There's revolution. We could always discard the Constitution, discard the laws, and overthrow the Constitution and replace it. That would be a revolutionary act, not a constitutional one. And I think even Washington would recognize, sure, you can do that, but boy, that's the nuclear option. That's not something judges do. That's not something we do on an ordinary basis. That's really stepping outside the system and doing something radical. So to create a constitution means we assume this is sort of fixed. Now, what about meaning? We're talking about meaning. Well, if the people have a right to make that constitution as binding in the future, then it has to have some sort of integrity, some sort of meaning, some discernible meaning that it has that doesn't just change over time, that doesn't change without that amendment. To say the Constitution stays the same, but its meaning changes, is to say that the Constitution is not in fact fixed. It doesn't remain the same. It doesn't remain the same pending amendment. So, really importantly, someone who argues the meaning of the Constitution is fixed is not saying that the Constitution doesn't change, right? The Constitution does change, has changed in some very important ways. But when it's legitimately changed, it's changed through the process laid out in the text itself. So what this means, let's talk about in terms of constitutional interpretation real briefly. What this means is that when you go to determine what does the Constitution mean, your most important guideposts are going to be the text itself, because the text is the law, or at least embodies the law that's made. And so you have to get whatever law you're going to get out of that text. Well, the text sometimes refers to ideas. It can even refer to pre-existing things, right? The text even refers to something, for example, the Constitution refers to the writ of habeas corpus. The Constitution doesn't tell us what the writ of habeas corpus is. What is that? Well, it's a pre-existing idea, a pre-existing principle, in this case, a legal mechanism, a means of a judge ensuring that a person who's imprisoned is imprisoned for a legitimate reason that existed under the English common law. So the Constitution takes pre-existing things, puts them in the text. So if we want to know what that means in the simplest sense, then we're going to look at its historical origins, its context. What did it mean when it was enacted? Now, I'll touch on one other dispute here, which is, and as you encounter the We the People text, you'll see this too, I think in some of Erica's slides later, you'll see this. We talk about plain meaning. The We the People text talks about plain meaning, and it talks about original intent. That is, what does that text mean on its face? That I think, if it in its most sophisticated form, is actually saying, what would a reasonable and informed person about the matters about which the Constitution speaks think those terms meant when they were enacted? That is, what is its original public understanding? Its original public meaning. That's a little different than another idea of original intent. Sometimes there's disputes about original public meaning. Maybe even at the time, the text could mean more than one thing. Or maybe the sense of a term was changing, right? The term federal was actually shifting in this period. So what do we mean when we use certain terms? Well, then sometimes people have recourse to original intent. I would say this is especially the case when we're talking about structure. A lot of times we talk about the Constitution, we're thinking about something like writ of habeas corpus or something like free speech. But sometimes we're talking about structure, how an institution works. Later, we're going to talk about whether the president can remove people from office, whether states can invalidate a federal law. Those are structural questions. So I think, especially on questions of structure, we can be helped by looking at original intent because we can look at the folks who are building the text like the engineers who design a machine. Who can best tell you how it works, right? How all the pieces fit together in a coherent whole. Well, maybe the people who design the instrument in a deliberative process, all those folks in the room arguing over it, maybe they have certain insights from their experience in that debate that can tell us something that people just reading the text at the time wouldn't necessarily understand. So I think that gives us at least a couple of tools that we're looking at, and we're going to encounter a lot of disputes. I think Hank's going to have some very real and very important criticisms of this fairly simple approach that I've set out. I won't say it's simple actually. You can all tell it's complex already, but I'll call it straightforward, right? This basic principle of a text that's enacted by the people and doesn't change until we amend it. I'll stop there.
All right, Hank.
It's a great start, and I will not criticize Matthew because he makes some fine points. But let me throw a little nuance in this. Let me try to share my screen, which is always dangerous. But real quickly to ask a question or to have us think about a question for just a couple moments. Let's see. Okay. Here we go. What the heck? All right. So here is a piece from the Constitution, a little piece from the Constitution, the Republican Guarantee Clause. Republican Guarantee Clause is in Article 4. That means that it was ratified in 1788. That is a fight in and of itself. I always called the Constitution of 1788. Some people call it the Constitution of 1787. They are wrong. Why? Because the Constitution was not the Constitution until it was ratified. It had to be ratified by 9 states, and that didn't happen until 1788. So, sorry, it's the Constitution of 1788. So it was ratified in 1788 by the ninth state to ratify it was New Hampshire. So arguably the meaning was set at that point, and Virginia coming in as a 10th state ratified what was already ratified. But that's a second piece of the puzzle, but that's one of the things that makes Matthew's point a very hard one to think about. Original intent and what people thought something meant at the time, there are a lot of people thinking a lot of things at the time. So it's really a much broader sense of what it could be interpreted to mean. Okay. Put that in mind. Let's ask this question about the Republican Guarantee Clause. The United States shall guarantee to every state in this union a Republican form of government. Okay. Our sense about what that means arguably has changed over time. Not because the words change over time, but because what we think a Republican form of government is may have changed over time. That is, in 1788, the notion that a whole bunch of citizens could simply be denied the ability to vote didn't change the nature of the Republican Guarantee Clause. Indeed, the question I ask, does or did this text have anything to say about women's suffrage, is an issue that at this point arguably doesn't matter because we have the 19th Amendment, but it mattered a lot in the wake of the ratification of the 14th Amendment when you had various groups, including women, arguing, well, the Republican Guarantee Clause is about whether the corpus of citizens are controlling their government, and you can't deny lots of citizens the right to be involved in voting for the government. The Supreme Court said, bah, pish posh. Technically, they didn't say pish posh, but pretty much they said pish posh at the time. But I think it's fair to say that that's in part because the nature of voting was different at that time than it is now. When you look at the constitutional amendments that have come since 1865, that have expanded the ability of folks to vote or limited the way that states can limit the right to vote, what we find is that voting is core to the concept of what a Republican form of government is. So we might well argue that even though the language was ratified in 1788, the way we ought to think about the principle of a Republican form of government has changed over time. That's something that happens with almost every piece of the Constitution, in part because the amendments to the Constitution have changed structure without redlining the document. We amend the Constitution by adding words at the end, not by redlining it. And as a consequence, some of the language that was ratified in 1788 or in 1865 or in 1868 or in 1870, etc., that language still has to be viewed through today's lens, namely the lens of new thoughts about what it is to be an American or an America. Let me stop there because Emily's got a look that says, shut up. We got to move on.
You bring up a really good point, though, Hank, and I think it does kick us nicely to the next question, which is who is actually doing the interpretation? And that kind of moves us from the idea of theory to the idea of constitution and practice. So, if I could have you both address that question briefly, who is actually doing the interpretation and how does that change things?
I'll jump in. I'll jump in first with something real quick. Arguably, every branch can do some interpretation. That is, the legislature arguably starts by interpreting the Constitution by not passing laws that are unconstitutional. Now, I know people would say, oh, they don't think very hard. Well, but they have a duty and they have an oath and they have a responsibility to support the Constitution. And as a consequence, you're not supposed to pass legislation that's clearly unconstitutional. Okay, so that's one piece of the puzzle. But the real fight that we think about and we've thought about from the beginning of the Republic is really the president and the courts. The courts will clearly tell us what is constitutional. There's plenty of quotes from John Marshall, certainly coming out of Marbury versus Madison, et cetera, and so forth, that the court's the final arbiter. That is fine, but a lot of constitutional interpretation goes on outside of the courts. And indeed, just for kicks, let me throw up this piece from 1862. Like, okay, he's going deep on us. Yeah, sure, why not? Okay, let's go to the Attorney General Bates opinion, 1862. Just going to throw it up there. Of course, in 1857, we had Dred Scott. The Dred Scott opinion coming out of the Supreme Court essentially said free black people cannot be citizens of the United States, period. That's what we learned. 5 years later, Attorney General Bates had to issue an opinion because the requirement was that anybody who was mastering a vessel on the coast had to be an American citizen. So Salmon Chase, the Secretary of Treasury, asked Attorney General Bates, well, what do you think about the fact that you've got black folks out there, black men out there as masters of vessels? So the Bates opinion asked the question, is a man legally incapacitated to be a citizen of the United States by the sole fact that he's colored, not a white man? Bates walked through the analysis and about 15, 17 pages later says, I give it as my opinion that the free man of color mentioned in your letter, if born in the United States, is a citizen of the United States, and if otherwise qualified, is competent according to the acts of Congress to be a master of a vessel engaged in the coasting trade. Attorney General in the executive branch clearly talking about an issue that sounds in constitutional law and in constitutional interpretation. And if you read the entire Bates opinion, you'd see he gets into the Constitution, etc. And this opinion essentially stood. So lots of people do interpretation in various ways. Certainly the court does, but the executive does as well. And anyone who doesn't recognize that has not been looking at our current president, who does a whole lot of constitutional interpretation off the cuff.
We may be in vehement agreement on this, Hank. I think that's absolutely right. Bates's decision was preceded by quite a few years by Lincoln's speech on the Dred Scott decision, where he points to this when he's still a candidate. way back in 1857 when he's trying to win the Illinois Senate seat and says, his opponent, Stephen Douglas, said, Supreme Court has answered this question. Can a black man be a citizen? And Lincoln says, well, the court answered the question, but they didn't settle it because one institution saying the Constitution means something doesn't settle it in America's constitutional order. Now, this is really, I was asked some time back to actually write an essay. It was sort of these pro-con essays for somebody's textbook, where I was sort of forced. I drew the short straw. I had to write the essay defending the finality of the Supreme Court. Do my best. What's the best case you can make? And I made a case for it. There is a case for the court being final, but even then, it's subject to all kinds of qualifications. Is the court final on certain questions of constitutional interpretation? The answer to that is yes. But when? Which questions? Why? Well, often they're final because of either their institutional position puts them in a place where there's really no appeal. If the Supreme Court says the courts of the United States will not hear cases of this kind, and judges are going to dismiss every prosecution you bring, every criminal prosecution where you're trying to prosecute somebody for burning a flag, and every time you walk into a courtroom, a judge says, case dismissed, that's unconstitutional, you can't bring this. Well, then the court's going to be final on the question. Because of their institutional position. I think sometimes, occasionally, you've seen this. Some justice at some point said we're not final because we're infallible. We're infallible because we're final. This idea that well, we're the last ones to decide, and you can't do it without our cooperation. Therefore, whatever we say about the Constitution stands. I will point out that only actually works when the court is saying no. So when is the court final? I'd say when you need courts to do something, to take action, like when you can't act without the courts being involved, then the courts have the opportunity to be final. If they keep saying no, they can prevent the government from carrying through on their preferred course of action. So that means the courts are most powerful when they're trying to prevent something from happening. I think the converse is also true. The courts are least powerful. They are weakest when they're trying to get other people to do something. That is, when the court is telling the government, by golly, you need to issue that passport to that person, or you should go get that person from Venezuela and bring them back up here, right? When the courts are trying to command other branches to do things, they're at their weakest. So courts do have points where they get to do this, but it is true what Hank says. Everyone interprets the Constitution, and who's going to win the interpretive battle? Well, it's going to depend on the issue. It's going to depend on the political circumstances. Who won out on the constitutionality of the Alien and Sedition Acts? Well, the federal courts were content with them. Many of the states, Jeffersonian states, said they were unconstitutional. That's the Virginia and Kentucky resolutions. Who won? Well, the states kind of won, but why did they win? Because they won the presidential and congressional elections. So if you win enough elections, you'll get your way on constitutional meaning eventually, even if the court comes sort of dragging its feet. So, who's going to be final? We don't know. That's only a story you can tell in retrospect. Who's going to be the last word on constitutional meaning, I think.
Thank you. That's such good food for thought. Okay, and that's going to cue us up nicely for two examples that we had thought about in advance. So one of the examples that we thought about, kind of using our different lenses to look at, were one of them is to do with structural powers, and specifically the removal power. So if the Constitution doesn't say clearly who can remove executive officials or how that's supposed to happen, how do we know? Hank, do you want to kick that off for us?
Yes, and I swear I will be very brief. Let me just throw up a quick PowerPoint on this particular point. So here's the thing: executive removal. The headline is executive removal, but really this is about putting folks into office. So it says, he, by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. The reason why I put this up is when you look at how people are put into office, that made some people argue that it should mirror how they could be removed from office. That is, if the Senate was required to advise and consent on putting someone into office, arguably that meant that the Senate surely should play some role if the president decided to remove people from office. That's the context. Some interpretation had to go on, and some of that interpretation occurred in the first administration with Washington. I said I would tee it up and be short. I am. I'll actually throw it open. I'll throw that open to Matthew to talk a little bit about what happened in that first administration, or whatever else you want to say about the issue of executive removal.
Okay. Executive removal. So I agree with Henry on this that the mode of appointment doesn't tell you who can remove. But I do think something else does give us a clue to who can remove. The vesting clause, which I think, well, Henry, did you say you were going to stick that up at some point too? Do you have the vesting clause on one of those nifty slides of yours? If so, I'm going to let you put it up there. And here's the reason why, if the presumption was that the power to remove follows the power to appoint, well, the president appoints all kinds of people. The Constitution doesn't intend the president to control. In fact, there's a debate about judicial appointment in the Constitutional Convention, where they're talking about, well, who should appoint? And at one point, some of the delegates are talking as though the power to appoint judges will mean some kind of control over them. And there are certain delegates who point out, said, that's not the question, actually. Because you could appoint somebody, and just because you gave them the job doesn't mean you get to control them in the future. So appointing someone has nothing to do with controlling them later. So the real question, whenever we're talking about who gets to remove, is, well, who should control this person's conduct? Who should oversee them? Who should be responsible for removing them? To whom are they responsible? And the better clue there comes from the vesting clause. The vesting clause, the first provision of Article 2, says the executive power shall be vested in a president of the United States. Period. That's the whole sentence. Now, you could compare that. I don't know if you've ever done this. Compare it with the other vesting clause in Article 1, one of the other two. Article 1 says, all legislative powers herein granted shall be vested in a Congress of the United States to consist of a Senate and a House of Representatives. And there you see that the legislature is plural. It consists of two different, is bicameral. The legislative powers Congress has are vested in two different bodies. And it's not just the legislative power, it's all legislative powers herein granted. It's a specific subset. So Article 2, though, gives us this very straightforward statement. The executive power, whatever that is, shall be vested, mandatory language, in a president of the United States. Now, the president's not going to exercise the executive power by himself. Executing the laws is a big deal. Nobody thought George Washington was going to go arrest people, though he did ride out in military uniform in the Whiskey Rebellion. But nobody thought he was going to do it by himself. So what happens to all those people who are exercising the executive power, executing the laws of the United States? Well, they're exercising the executive power. And where does the executive power reside? In the president. That's where the Constitution puts it. So when you get to the question of removal, the question of removal is not so much about who appointed, but who's responsible for the exercise of power that's going on. And this was an argument that a certain number of folks, in some cases very important folks in the first Congress advanced, and others, though there were other ways of looking at this, advanced this argument. That meant when it comes to controlling somebody exercising the executive power, the president needed to have the ultimate ability to do that. Now, does that mean the president has to be able to fire them? Is somebody immune from presidential control just because the president can or can't fire them? Well, that's a disputed question too, but it is certain that whoever exercises the executive power is ultimately responsible to the president of the United States. Now, we also know there's another provision in the Constitution, Article 1, Section 8, which ends with the necessary and proper clause, which we usually think about when it comes to federal power, but actually has something to do with separation of powers, not just federalism, because it says all powers that, in addition to all the stuff enumerated, Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, that's the list of stuff Congress can do, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So anybody wielding federal power, Congress gets to make necessary and proper laws for carrying their powers into execution. I'll make this brief because I think that power does give Congress the power to structure executive institutions, provide for executive officers, even give some rules for the way they operate and carry out federal law. But I don't think at any point that power to carry into execution the powers of the president gives Congress the power to then frustrate the president's control over those charged with executing the law. So I think there's a limit to Congress's power in the necessary and proper clause. I think you have to read those together. Congress gets a lot of power, but not so much that Congress comes to itself exercise executive powers. So I'll leave it there.
Okay, thank you. So that's sort of complicating the idea of interpretation when we need to kind of fill in the gaps of what the Constitution says explicitly. And then our other case study that we wanted to take a look at tonight was the 14th Amendment. So specifically, the first portion pertaining to all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. Okay, so we have words this time, but what happens when this same text then is read and interpreted differently? So once again, I'm going to let Hank take the lead.
So all right. Let me do this as, again in terms of narrowing the issue because I know that time is a question. So let's think about the citizenship clause or the birthright citizenship clause. So this came out of course, 14th Amendment in the wake of the Civil War and in the wake of the Civil Rights Act of 1866, which is important to note that this piece about birthright citizenship was put in a statute that was passed pursuant to the 13th Amendment before it found its way into the 14th Amendment. There's more there, but we don't have time to go into that. Just something to think about the concept that one could legislate on an issue that you eventually then pass an actual amendment on. But here's the piece that I want us to consider in terms of thinking about interpretation. The question I ask at the bottom is, did this clause make free blacks citizens or did it merely recognize their citizenship? An important issue if you took Dred Scott to be the last word on whether free blacks could be U.S. citizens. If you took Dred Scott's position or the court's position as the law and the constitutional law, then we might well argue that the 14th Amendment, Section 1, made free blacks citizens. If, on the other hand, you take Dred Scott's position as just being amusing on the law, a contemplation of the law, but not a real statement of the law, then you might argue that Section 1 of the 14th Amendment merely recognized the pre-existing citizenship of free blacks and now of freed slaves. The issue arose in a situation in the late 1860s, early 1870s in the U.S. Senate when Hiram Revels, a free black man who was born free, was approved by the Mississippi legislature to serve as U.S. Senator from Mississippi. So the question that was asked was, could the Senate seat him? The reason why that question was asked was because, of course, U.S. senators have to be U.S. citizens for, I believe it's 9 years in order to be qualified to serve. Well, if the birthright citizenship provision created black citizenship, then this free black man had not been a citizen for 9 years. If, on the other hand, it merely recognized his pre-existing citizenship, then he had been a citizen for more than 9 years and was able to serve. The U.S. Senate, in asking that question or in thinking about that question, had hearings, they heard from him, they thought about what this section meant, and eventually determined we're going to seat Hiram Revels as a senator from Mississippi arguably interpreting this piece to say it simply recognized the citizenship of black folks. Now, there were others who disagreed, but it was this interpretation of the position that was out there. So we just want to think about the idea that the words on the paper don't necessarily tell the full story. Constitutional law is developed through stories, through situations, through cases that try to apply the particular meaning. And there are tons of stories out there that are just as fascinating. But I'll stop there for now.
I put a quote in the chat. Felix Frankfurter. The ultimate touchstone of constitutionality is the Constitution itself and not what the judges have said about it. So I think Congress, remember the dealing with Hiram Revel's case, are working on this assumption. The court didn't change the Constitution or what the Constitution means by wrongly deciding Dred Scott versus Sanford. Um, and thankfully, the court ultimately loses in that whole thing. But certainly, at the very least, the 14th Amendment an exclamation mark on the fact that no, in fact, people born or naturalized in the United States are citizens of the United States. Now, you all know that the current controversy over this text is, of course, Congress has a power to enforce the 14th Amendment. That includes making laws carrying into execution this provision, deciding how does this apply? How do we establish who's born or naturalized in the United States? By that, for that matter, it says or naturalized, so Congress gets to make rules on naturalization, how people become citizens, and they get to settle disputes over that or modify those laws over time. So, can Congress identify classes of people who are born in the United States, but somehow don't receive this benefit? And that's been the controversy we face now. The 14th Amendment itself, if you look in the text, and I recommend highly you look at it, all persons born or naturalized in the United States and subject to the jurisdiction thereof. So folks have pointed out that there then are a category of people who might be born here and not subject to the jurisdiction of the United States. There are two categories of folks that we know fall in that category or would have when this language was adopted. That would be children born to soldiers accompanying foreign armies. So if there was an invading army, the Mexican army invaded and someone gave birth while they were here, they would not be a citizen. So invading armies weren't covered. And of course, the children of diplomats or officials of foreign governments who were here under diplomatic immunity, they're not subject to the jurisdiction of the United States. Now, it's interesting because the question is, what about anybody else? Are there any other categories of people? And quite a few folks have argued that there might be. I will say, Henry mentioned the Civil Rights Act of 1866, which was supposed to enforce the 13th Amendment. It had almost the same provision as Section 1 of the 14th Amendment, but it was a little different. It said all persons born or naturalized in the United States and subject to no foreign power are citizens of the United States and the state in which they reside. So is the exclusion, is the category of people who are subject to no foreign power, is that the same category as subject to the jurisdiction of the United States? And the language, the plain reading of that would suggest, no, those are two different descriptions. I could be subject to the jurisdiction of the United States and subject to the jurisdiction of a foreign power too, right? So it would seem if we just had the Civil Rights Act of 1866 and the 14th Amendment had never passed, Congress would be able to exclude a lot of people who were maybe here temporarily, but still subject to some foreign power. They remain citizens of a foreign power. But the 14th Amendment, the language adopted, is narrower than that. It says, and subject to the jurisdiction, anyone subject to the jurisdiction of the United States and born in the United States is a citizen. Now, here's the interesting thing. That's a plain meaning. That's sort of a plain text. If we looked at the plain meaning of the text, that's what we get. And I think that's a pretty sound way to proceed. I'm usually inclined to just stop there. You get a plain meaning out of the text, you stop. But some folks have looked at the debate in Congress and they've said, well, it looks like in the debate, certain members seem to assume this language actually meant the same thing. Nothing actually changed. It looks like it might, but the understanding at the time was that in both cases, maybe, Congress had in mind the same sets of people who were excluded. And a big category of these folks, of course, most of the debate in Congress was consumed not with foreign citizens, but with Indian tribes. People born in the United States who are members of Indian tribes. Are they subject to the jurisdiction of the United States? Are they subject to a foreign power under the Civil Rights Act? So that's where sometimes uh, we get we can actually get sort of decisions that point in opposite directions out of the legislative debate and a plain reading of the text. Um, I tend to think the plain reading of the text is enough here. It looks like Congress said subject to the jurisdiction there, and that looks pretty narrow. But it's been a very robust debate now over can you fit anyone else in the category of people not subject to the jurisdiction of the United States. For example, folks who are here illegally or folks who are here temporarily on vacation. How can you do this? And of course, there's always the fallback. To me, one answer to this is who does the amendment itself say enforces the amendment? Congress. Congress shall have power to enforce the provisions of this amendment by appropriate legislation. So now Congress is not the president. Current controversy is the only executive order. So whom should we defer to on this question? Well, I'd suggest that one answer with the 14th Amendment is Congress might actually deserve some deference in the case of the 14th Amendment because the amendment itself specifically says Congress enforces it, which entails deciding what it means to some extent. So it's one way of approaching this that's sort of based in the text itself.
Thank you. Both
One,
Hank.
one, one
Yep,
real quick
yeah.
30 second pinch
I'll give you 30
before
seconds.
we hear from Erica. One pinch is I'm wearing my pullover because it's a Center for Civic Education pullover. So much love to the center. Otherwise, I'd be wearing a jacket like Matthew, but that's okay, and maybe even a tie. But all right, that's number one. Number two, shout out to you, James Butler, because I grew up in Prince George's County. Much love to you. Third piece of the puzzle, and last piece of the puzzle is this. What Matthew just said about the legislative debate is a fascinating piece that rolls us back to the concept of whose interpretation matters. It matters what was said in the debate, but for my purposes, what really matters is what the ratifiers thought it meant. And if you go to the states that ratified the 14th Amendment, you're going to see a whole bunch of other ideas out there, and some ideas that would say we want a broader or a narrower vision of what the 14th Amendment means. That's not to disagree with what Matthew's saying. It's just to say that there are a lot of people out there who had a lot of views on what the 14th Amendment meant. And if we're thinking about original public meaning, we'd actually need to take into account all of those visions, not to come to a single definition or a single interpretation, but to recognize that there's actually a multiplicity of definitions out there from which we ought to work through in order to figure out what the document actually means. Sorry, I'll stop there.
No, thank you. That was a great summation. And I'm gonna let those ideas kind of percolate with folks for a little bit while we give over the floor to Erica.
I'm going to throw a couple of answers in the chat to these questions that popped up because we didn't answer them
Absolutely.
verbally, but I'll throw some answers in the chat to these questions while
That will
we're.
be great. So thank you so much. And Erica, please go ahead and take it away because these are obviously really complex topics that I'd love to talk about how you work with your students to better understand.
Yes, so I use the We the People textbook, specifically lesson 22 to teach this. And so I start with looking at the Fourth Amendment and pointing out that the Fourth Amendment protects citizens against unreasonable searches and seizures. And so asking the students, how would you decide what makes a search or seizure unreasonable? And then they also look at identifying the advantages and disadvantages of each method provided. And so students look at, okay, would I look up unreasonable in a dictionary to find out what it means? Would I try to find out how the framers might have explained the word unreasonable? Or examine the word unreasonable in relationship to basic ideas as natural rights and limited government? Would they examine the word unreasonable in relation to the historical, political, and social changes that have occurred since the Constitution was written, or even rely upon previous court rulings on what they said was unreasonable searches and seizures. So then I like to just go over with the students, define uh, the different ways to interpret the Constitution, the plain meaning, the intentions of the framers, the fundamental principles, and today's societal values and needs. And again, looking at what are the advantages and the disadvantages of each way. So here are the definitions. I did put a copy of this in the chat, so if you want to look at it in more detail on your own time, you can. But then we also look at the concerns of each one. And so again, I will let you, because of time, look at this, on your own time, your convenience of the concerns of each interpretation. And then I put it into the students' hands where we put this into practice. And I like to remind the students of the civic disposition, civil discourse, that we are going to hear different ideas, but we are respectful, when we discuss these topics. And so the We the People textbook focuses on interpreting the Second Amendment. But this year, my students were really interested in interpreting the 14th Amendment and that birthright citizenship. So again, we went through each of the different ways to interpret the 14th Amendment. And the students can see that through different lenses, you have the same words, but a different interpretation can lead to a different conclusion. So if you decide to do this with your students and you want to focus on the Second Amendment, I do have some follow-up questions that you can ask them for discussion. And then again, putting it in their hands, if you are a member of the U.S. Supreme Court and you are going to hear a case involving let's say government agencies watching sites that citizens visit on the internet. Well, this technology did not exist when the Constitution was written. And so asking the students, how would they determine whether this practice is unconstitutional? And then finally, looking at two different quotes from Supreme Court justices. Charles Evan Hughes, we are under a constitution, but the Constitution is what the judges say it is. Or Felix Frankfurter, as a member of this court, I am not justified in writing my opinions into the Constitution, no matter how deeply I may cherish them. So I encourage you again, on your own time, just for the sake of time here, we're reaching 8 o'clock. Feel free to click that link, follow along, just for a little bit more details of how you can reach your students and just make this practical and real for them. I teach 8th grade, and the students were just very excited to link what we're learning about in history class to modern events that are happening right now.
Hey, Erica, can I ask you, when you talk with your students about this, do y'all talk about who should decide whether the Fourth Amendment applies only to the federal government or whether it should also apply to the state government?
We do look at federalism in that way as well, just because, when they're looking at it, do we look at the words, but then also some students will, bring up the 10th Amendment and states' rights in there as well. We have discussed that.
Cool.
That's great. Thank you, Erica, and thank you very much for sharing your presentation. Okay, so there was one more question in the chat that I'm wondering if we can get at least your thoughts on before we close out for this evening, because I think it's a really important one. So Sam asked, when faced with a constitutional decision interpreting and applying the text, which they think might be disastrously wrong, how ought a citizen or elected official respond? So I'm going to leave it with that because I'm not sure the chat translates when we do the recording, but let's make sure that we get Hank and Matthew's thoughts on that before we go.
So I'll take a first pass at this real quick. I did write a response in the chat that's an incomplete one. So when a lower court is faced with a decision with which they disagree, the answer to this question is simple. They're bound by the decision of the superior court. That is, they're responsible to a superior court or an inferior court. So they implement the decision They may find ways to distinguish a case in front of them and say, well, this isn't quite like the case the Supreme Court decided, so we're going to follow our own judgment anyway. I will say we're dealing with a different instance when we deal with the president and Congress. They're not subordinate to the Supreme Court. They are, in fact, constitutionally the equals in terms of constitutional authority with the Supreme Court. They all derive their power directly from the Constitution. So when we're dealing with that sort of situation, so I think it's clear that the Congress and the Supreme Court, or Congress and the president, can follow their own judgment to some extent. We can argue over the details. Lower courts don't get to. Now, I think the hardest question to answer is actually, what about states? What about states? What about when a federal court says something that state courts and state officials disagree with? Should we treat them like Congress and the president as not subordinate to the courts? Or do we treat them like subordinates under the Supremacy Clause? And I think that's quite hard. I think, and here's one line of distinction I would draw. If we're dealing with a question of federal law, what federal law means, I'd go with Andrew Jackson and John Marshall and Abraham Lincoln on this one. Federal institutions are the last word on what federal law means. On the other hand, if we're dealing with a disagreement over what state law means and whether it's constitutional or not, I think you have a more difficult situation. Figuring out whether states have a power kind of like Congress and the president to push back on a constitutional determination they disagree with. So I think that can be a disputed question. But generally speaking, a question of federal law is settled finally by some federal institution, but not always the Supreme Court. Hank, what do you have to say about that?
Yeah, I think Sam asked a great question. One of the messy parts about it is, I think part of the question may also have been, what should students talk about in terms of that? I am more than happy to have students just say, I think the court got it wrong for a couple reasons. One is that for a lot of controversial decisions, you're going to have dissents. The dissenters are just as smart as the folks in the majority. So there's nothing wrong with saying, I just think they got it wrong. That's one. Number two, the court will say that it has gotten cases wrong in the past. I mean, we certainly heard Chief Justice Roberts. I can't remember which case it was, but he finally said, yes, Korematsu was wrong, and it was wrong the day it was decided. Now, easy to say that, with some hindsight, or easy to say that when that doesn't cost you anything, but they flip on cases over time. We certainly saw that with Roe and Dobbs. So I have no problem with students challenging court decisions and saying we think they got it wrong. I do think it puts a bigger onus on the students to explain why they got it wrong. But I have no problem with saying, gee, I think the court got it wrong. Heck, that's how I make my money, is by complaining about courts getting things wrong. So in that respect, I've got no problem with that whatsoever. One just needs to be careful that in fact one is correct when one jumps a court and says, "Hey, they got it wrong."
Can I throw in one pithy? I can't resist to say the notion that the court gets things wrong must mean that the Constitution has a discernible meaning, that we can get wrong or right. And sometimes the court does a bad job of interpreting it. And in hindsight, we like to say that. But I think we have to recognize that that means we must think there's a meaning in there somewhere that we can do well or poorly at discerning.
I feel like that probably ties it back to Unit 1 of We the People and the philosophy the philosophy angle, which we could spend an entire other day discussing. Well, as we are at time for our 60-minute civic session for tonight, I really want to thank our speakers this evening, Dr. Matthew Brogdon, Dr. Hank Chambers, and Erica Pagano. Thank you so much for helping us kind of think about some very big, very hard to wrap your brain around issues in a way that actually did help not necessarily clarify things, but give us more avenues of ways that we can better understand the ongoing disagreements about constitutional interpretation. This was a tall ask, and I really appreciate you being willing to spend some time with us tonight and answering our questions.
Can I just smart out for just 1 second?
Of course.
Yeah, one of the things that I'll tell people about constitutional interpretation and the notion that it changes over time is for folks who have been in relationships or married for a long time, recognize that the things that we say at one point mean something different than at some other point. My wife and I have been married for 33 years. When I said to her, I love you, honey, back in 1992, that meant something different then than it means when I say exactly the same thing today, 3 children and 3 decades later. It's not that what I meant back then isn't part of what I mean now, but the fact that I'm saying the same words doesn't mean that it doesn't have a more nuanced meaning. The Constitution is that way in a lot of ways. What it meant in 1788 is a little different than what it means now because it's a living document. I hope that's the last word. Matthew shouldn't be able to answer that. Bye.
I mean, it would be pretty hard to top that one. I mean, to be honest. But thank you to all of you for sticking with us. That's a great analogy. And we hope that you'll be able to join us for a future 60-minute civic session. We actually have a session next Thursday that we hope you might consider as well, about teaching the 250th anniversary of the Declaration of Independence. We'll be joined by Dr. Jane Kamensky from Monticello for that event. So we hope you'll join us for that or some future event. But thank you again so much for joining us tonight. And thanks again to our scholars. And we'll see you next time.